Section 1 of Worker Classification, Employee Status under the National Labor Relations Act, the Fair Labor Standards Act, and the ABC Test by the Congressional Research Service. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Worker Classification, Employee Status under the National Labor Relations Act, the Fair Labor Standards Act, and the ABC Test by the Congressional Research Service. Summary: the classification of workers as employees rather than independent contractors is critical for purposes of most federal and state labor and employment laws. In general, the rights and protections afforded by these laws are available only to employees and not to independent contractors. Courts and administrative bodies have used various tests to make worker classification determinations in light of the vague or circular definitions that have been adopted for the term employee in some labor and employment laws. This report examines two such tests: the Common Law Agency Test and the Economic Reality Test. The report also discusses the so-called ABC Test, which has been adopted in at least 20 states and the District of Columbia to determine employee status for purposes of various state labor and employment laws. Legislation that would adopt the ABC test for purposes of one federal labor and employment law, the National Labor Relations Act, or NLRA, was approved by the House of Representatives in March 2021. The Common Law Agency Test is currently used to determine employee status for purposes of the NLRA, which recognizes a right to engage in collective bargaining for most private sector employees. Applying the test, courts and the National Labor Relations Board, or NLRB, the federal agency that enforces the NLRA, consider a variety of factors derived from the Restatement Second of Agency to determine whether a worker is an employee or an independent contractor. These factors include the extent of control exercised by a hiring entity over the worker, whether the worker is engaged in a distinct occupation or business, and the level of skill required by the worker to provide services. In 2019, the NLRB indicated that a worker's entrepreneurial opportunity for economic gain or loss would be a prism through which to examine the common law factors. The Economic Reality Test is currently used to determine employee status for purposes of the Fair Labor Standards Act, or FLSA, the federal law that requires employers to pay a minimum wage and overtime compensation for hours worked in excess of a 40-hour work week. Federal appellate courts have generally identified 6 factors that should be considered to determine whether a worker is an employee or an independent contractor for purposes of the FLSA. These factors include the nature and degree of control exercised by the hiring entity over the worker, and whether the worker invested in equipment or materials to perform the work. Although courts have indicated that all of the factors should be considered, the U.S. Department of Labor recently promulgated a rule that emphasized 2 factors: a worker's entrepreneurial opportunity for profit or loss, and the hiring entity's control over the worker as more determinative of employee status. Unlike the Common Law Agency Test and the Economic Reality Test, the ABC Test presumes that a worker is an employee. The worker will be classified as an independent contractor only if the hiring entity can satisfy the test's 3 elements. A, the individual is free from the entity's control or direction in performing his work, both under a contract for the performance of such work and in fact. B, the work performed by the individual is outside the usual course of the entity's business. And C, the individual is customarily engaged in an independently established trade, occupation, or business of the same nature as the work performed for the entity. While the reasons for adopting the ABC test may vary, at least some states have expressly described an interest in preventing employers from misclassifying their workers to avoid labor and employment law obligations. End of section 1. Section 2 of Worker Classification, Employee Status under the National Labor Relations Act, the Fair Labor Standards Act, and the ABC test by John Shimabukuro of the Congressional Research Service. This LibriVox recording is in the public domain. The classification of workers as employees rather than independent contractors is critical for purposes of most federal and state labor and employment laws. In general, the rights and protections afforded by these laws are available only to employees and not to independent contractors, defined as individuals who are retained to complete a specific project but are free to do the assigned work and to choose the method for accomplishing it. The misclassification of workers as independent contractors leads not only to the denial of entitlements like overtime compensation, but also results in economic loss to the government. The U.S. Department of Labor has observed, quote, employee misclassification generates substantial losses to the federal government and state governments in the form of lower tax revenues, as well as to state unemployment insurance and workers' compensation funds, unquote. Because labor and employment laws often define who may be considered an employee in a vague or circular fashion, courts and administrative bodies have adopted various tests for making classification determinations. In general, these tests require consideration of various factors, such as the control exercised by an alleged or putative employer over the worker, to determine whether an individual is an employee or independent contractor. Notably, different laws may require the use of different tests, with some tests possibly emphasizing certain factors over others. This report examines the tests used to determine employee status for purposes of two federal labor and employment laws, the National Labor Relations Act, or NLRA, which recognizes a right to engage in collective bargaining for most private sector employees, and the Fair Labor Standards Act, or FLSA, which requires employers to pay a minimum wage and overtime compensation for hours worked in excess of a 40-hour work week. In addition to being two discrete tests, both have recently been reconsidered by the federal agencies that enforce the NLRA and FLSA. The report also reviews the so-called ABC test, an alternative test that has been adopted by at least 20 states and the District of Columbia to determine employee status for purposes of state unemployment compensation programs and at least some state employment laws. Unlike the tests used for the NLRA and FLSA, the ABC test presumes that a worker is an employee. The individual would be classified as an independent contractor only if the hiring entity can satisfy the test's three elements. The test is deemed the ABC test because of this standard. Some have argued that the ABC test should be used generally for employee status determinations because it provides greater predictability for workers. Legislation that would adopt the ABC test to determine employee status for purposes of the NLRA was recently approved by the U.S. House of Representatives. National Labor Relations Act. The NLRA attempts to mitigate and eliminate labor-related obstructions to the free flow of commerce by encouraging the practice and procedure of collective bargaining. Section 7 of the NLRA states, quote, employees shall have the right to self-organization, to form, join, or assist labor organizations, to bargain collectively through representatives of their own choosing, and to engage in other concerted activities for the purpose of collective bargaining or other mutual aid or protection, unquote. The NLRA requires an employer to negotiate in good faith with a labor organization that becomes the exclusive representative for a bargaining unit of employees. Independent contractors are specifically excluded from the NLRA's definition for the term employee. Thus, independent contractors do not enjoy the rights and protections afforded by the law, and an employer is not required to negotiate with them over the terms and conditions of their employment. To determine whether a worker is an employee or independent contractor, the National Labor Relations Board, NLRB or Board, the federal agency that administers the NLRA, applies a common law agency test that examines various factors derived from the restatement second of agency. These factors include the extent of control a hiring entity exercises over the worker, whether the worker is engaged in a distinct occupation or business, and the level of skill required of the worker to provide services. Footnote: Restatement Second of Agency, Section 220, Sub 2, by the American Law Institute, 1958. Quote, in determining whether one acting for another is a servant or an independent contractor, the following matters of fact, among others, are considered. A. The extent of control which, by the agreement, the master may exercise over the details of the work. B. Whether or not the one employed is engaged in a distinct occupation or business. C. The kind of occupation, with reference to whether, in the locality, the work is usually done under the direction of the employer or by a specialist without supervision. D. The skill required in the particular occupation. E. Whether the employer or the workman supplies the instrumentalities, tools, and the place of work for the person doing the work. F. The length of time for which the person is employed. G. The method of payment, whether by the time or by the job. H. Whether or not the work is part of the regular business of the employer. I. Whether or not the parties believe they are creating the relation of master and servant. And J. Whether the principal is or is not in the business. Unquote. Returning to the text. In applying the common law agency test, the NLRB and courts have indicated that no one factor is determinative, and that the relationship between a hiring entity and an individual should be evaluated in its entirety. In NLRB versus United Insurance Company of America, a 1968 case involving the employment classification of a group of insurance workers, the U.S. Supreme Court observed, quote, there is no shorthand formula or magic phrase that can be applied to find the answer, but all of the incidents of the relationship must be assessed and weighed with no one factor being decisive. What is important is that the total factual context is assessed in light of the pertinent common law agency principles, unquote. The party asserting an individual's classification as an independent contractor has the burden of establishing that worker status. Since universal insurance, the NLRB has on occasion revisited the use of the common law agency test to determine employee status. For example, in FedEx Home Delivery, a 2014 case involving the package delivery company's drivers, the board explained the significance of considering a worker's entrepreneurial opportunity for economic gain or loss when applying the common law agency test. Although the board had previously considered entrepreneurial opportunity in the past, it sought in FedEx Home Delivery to more clearly define the analytical significance of this factor. A majority of the board maintained that no one factor is decisive, that it would give weight to only actual and not theoretical entrepreneurial opportunity, and that any constraints imposed by a company on an individual's ability to pursue such an opportunity would be considered. Notably, consistent with the court's decision in Universal Insurance, the board majority emphasized that entrepreneurial opportunity should be considered together with the other common law factors. The majority noted that, along with evaluating the relevant common law factors, it should also consider whether the evidence demonstrated that the putative independent contractor is, in fact, rendering services as part of an independent business. Applying the common law agency test to the FedEx drivers, the board majority concluded that the workers satisfied most of the common law factors and should be considered employees and not independent contractors. The majority found that FedEx exercised pervasive control over the drivers' day-to-day work, that the drivers performed duties that were a regular part of FedEx's business, and that no special skills were required for the drivers to perform their duties. Moreover, the majority maintained that the drivers had little entrepreneurial opportunity for gain or loss for them to be considered independent contractors. For example, the majority considered the fact that the drivers' arrangement with FedEx prevented them from working with other employers, and that the drivers' work commitment to FedEx hindered their abilities to pursue other commercial opportunities. The majority also noted the drivers' inability to exercise control over FedEx's business strategy or change the prices charged to customers as evidence of the drivers' status as employees. Nevertheless, a dissenting board member criticized the majority's evaluation of the drivers' employee status, contending that the majority reduced entrepreneurial opportunity for gain or loss to a mere sub-factor in their analysis. The dissent identified the driver's ability to sell their delivery routes, in particular, as evidence of actual entrepreneurial opportunity, and maintained that the majority failed to consider the full impact of what a sale signifies in the context of the common law test. End of Section 2. Section 3 of Worker Classification, Employee Status under the National Labor Relations Act, the Fair Labor Standards Act, and the ABC Test by John Shimabukuro of the Congressional Research Service. This LibriVox recording is in the public domain. SuperShuttle DFW. In 2019, a new board majority overruled FedEx Home Delivery, criticizing that decision for minimizing consideration of entrepreneurial opportunity when determining employee status. In SuperShuttle DFW, a case involving drivers who were contracted to provide services for the shared ride van company, the majority contended that, as the facts may warrant, entrepreneurial opportunity is a prism through which the common law factors should be examined. The majority indicated that employee status determinations should continue to require consideration of the various common law factors, but emphasized that a worker would be deemed an independent contractor when a qualitative evaluation of the factors demonstrate an opportunity for economic gain or loss. According to the majority, entrepreneurial opportunity is a, quote, principle by which to evaluate the overall effect of the common law factors on a putative contractor's independence to pursue economic gain, unquote. The majority in SuperShuttle maintained that the 2014 standard in FedEx Home Delivery focused too heavily on economic dependency and a company's control over workers. The majority observed that, quote, large corporations such as FedEx or SuperShuttle will always be able to set terms of engagement, But this fact does not necessarily make the owners of the contractor business the corporation's employees, unquote. The majority thus determined that, quote, where a qualitative evaluation of common law factors shows significant opportunity for economic gain, the board is likely to find an independent contractor, unquote. Applying this standard, the SuperShuttle majority concluded that the drivers were independent contractors and not employees, citing the driver's ability to work as much as they choose, their discretion in choosing assignments, and their entitlement to the money earned from their chosen assignments. The majority maintained that the drivers have a, quote, significant opportunity for economic gain and significant risk of loss, unquote. Moreover, the majority contended that these factors were not outweighed by any countervailing factors that might support the conclusion that the drivers were SuperShuttle employees. Criticizing the standard adopted by the majority in SuperShuttle, the dissent maintained that the standard's focus on entrepreneurial opportunity was inconsistent with how the common law agency test was meant to be conducted. The dissent contended that by emphasizing entrepreneurial opportunity, the new standard applied the kind of shorthand formula that was criticized by the court in United Insurance. Even when considering the driver's entrepreneurial opportunity, the dissent argued that such opportunity was minimal at best, as it is SuperShuttle that creates, controls, and constrains that opportunity. The board has continued to apply the SuperShuttle standard to make classification decisions. In a 2019 advice memorandum involving the rideshare platform Uber, the board considered the proper classification for UberX and Uber Black drivers by applying the common law agency test as explicated in SuperShuttle. While it acknowledged that several factors point toward employee status, the board contended that those factors were overwhelmed by the evidence supporting independent contractor status. With regard to UberX drivers in particular, the board observed, quote, considering all the common law factors through the prism of entrepreneurial opportunity set forth in SuperShuttle, we conclude that UberX drivers were independent contractors. Drivers virtually complete control of their cars, work schedules, and log-in locations, together with their freedom to work for competitors of Uber, provided them with significant entrepreneurial opportunity. On any given day, at any free moment, UberX drivers could decide how best to serve their economic objectives by fulfilling ride requests through the app, working for a competing rideshare service, or pursuing a different venture altogether. The board further maintained that Uber Black drivers worked in a manner similar to the UberX drivers. Accordingly, they were also found to be independent contractors. End of Section 3. Section 4 of Worker Classification, Employee Status under the National Labor Relations Act, the Fair Labor Standards Act, and the ABC Test by John A. Shimabukuro of the Congressional Research Service. This LibriVox recording is in the public domain. Fair Labor Standards Act. The FLSA requires an employer to pay an employee a minimum wage, as well as overtime compensation at a rate of not less than 1 1/2 times an employee's hourly rate for hours worked in excess of a 40-hour work week. Section 3E1 of the FLSA defines the term employee simply to mean any individual employed by an employer. Courts have construed the term to exclude independent contractors. Whether an individual is an employee or independent contractor is often a threshold question that must be answered to determine whether the FLSA's requirements apply. In Rutherford Food Corporation v. McComb, The U.S. Supreme Court observed that the existence of an employer-employee relationship, quote, does not depend on isolated factors, but rather upon the circumstances of the whole activity, unquote. In Rutherford Food, the court concluded that a group of slaughterhouse workers were employees of a meatpacking company after considering a variety of factors, including the use of the company's premises and equipment to complete the relevant work. In subsequent decisions, the court maintained that the economic reality of a working relationship will determine whether an individual should be considered an employee or independent contractor for FLSA purposes. Federal appellate courts have generally identified 6 factors as particularly probative for evaluating the economic reality of such a relationship. 1. The nature and degree of an alleged employer's control as to the manner in which the work is to be performed. 2. The alleged employee's opportunity for profit or loss depending upon his managerial skill. 3. The alleged employee's investment in equipment or materials required for his task or his employment of workers. 4. Whether the service rendered requires a special skill. 5. The degree of permanency and duration of the working relationship. 6. The extent to which the service rendered is an integral part of the alleged employer's business. Because the economic reality test is fact-specific, workers in similarly labeled positions have sometimes been classified as employees covered by the FLSA, but in other instances they have been considered independent contractors. For example, janitors have been classified as employees as well as independent contractors after applying the economic reality test. In Boulage versus Willamette Real Estate and Management Company, a janitor who provided maintenance, landscaping, and repair services for the defendant's residential properties alleged violations of the FLSA's overtime provisions. The real estate management company argued that the janitor was an independent contractor who was not subject to these provisions. Applying the economic reality test, the federal district court in Boulage contended that all 6 of the relevant factors weighed in the janitor's favor. For example, the court noted that the company exercised control over the manner of the janitor's work by instructing him to perform specific duties, setting his work schedule, monitoring the quality of his work, and disciplining him when his work did not meet expectations. The court also found that the janitor did not possess an opportunity for additional profit or loss because his compensation consisted of a fixed salary and a rent-free apartment at one of the properties. In contrast, the U.S. Court of Appeals for the 10th Circuit concluded that another janitor was an independent contractor and not an employee for purposes of the FLSA. Like the janitor in Boulage, the janitor in Barlow versus C.R. England argued that the defendant, a trucking company that operated a maintenance yard, violated the FLSA's overtime provisions. The defendant contended that the janitor provided his services as an independent contractor, particularly because he formed his own cleaning company and provided his services pursuant to an agreement between the parties. Applying the economic reality test, the 10th Circuit acknowledged that some of its factors supported the janitor's position, while others favored the trucking company. For example, the court noted that the company, and not the janitor, provided cleaning supplies for the work. Ultimately, however, the court determined that the janitor was an independent contractor. The court found that the relationship between the trucking company and the janitor did not involve employment, but instead resembled a business relationship the company would have with any other cleaning service. The court also acknowledged the janitor's freedom to determine how he would accomplish his work. Rather than being an employee of the trucking company, the plaintiff, quote, was in business for himself as a janitor, unquote. Finally, how a hiring entity characterizes the individual will not determine a worker's employee status. In Scantland versus Jeffrey Knight, Inc., a 2013 case involving technicians who installed and repaired cable, internet, and digital phone services, the U.S. Court of Appeals for the 11th Circuit observed that its inquiry into the working relationship was, quote, not governed by the label put on the relationship by the parties or the contract controlling that relationship, but rather focuses on whether the work done, in its essence, follows the usual path of an employee, unquote. End of section 4. Section 5 of Worker Classification, Employee Status under the National Labor Relations Act, the Fair Labor Standards Act, and the ABC Test by John A. Shimabukuro of the Congressional Research Service. This LibriVox recording is in the public domain. Independent Contractor Rule. Motivated by its belief that the economic reality test has become, quote, less clear and consistent, unquote, in its application, the U.S. Department of Labor, or DOL, proposed a new independent contractor rule in September 2020. The rule was intended to be the agency's sole authoritative interpretation of independent contractor status under the FLSA. Discussing the need for the new rule, DOL explained, quote, the economic reality test's underpinning and the process for its application lack focus and have not always been sufficiently explained by courts or the department, resulting in uncertainty among the regulated community. The department believes that clear articulation will lead to increased precision and predictability in the economic reality test's application, which will in turn benefit workers and businesses and encourage innovation and flexibility in the economy, unquote. Like the economic reality test, the new rule describes factors that should be evaluated to determine whether an individual is properly classified as an employee or individual contractor. The rule identifies the following 5 factors to be considered. 1. The nature and degree of control over the work. 2. The individual's opportunity for profit or loss. 3. The amount of skill required for the work. 4. The degree of permanence of the working relationship between the individual and the potential employer. 5. Whether the work is part of an integrated unit of production. Unlike the economic reality test, however, the new rule characterizes the first 2 factors, the nature and degree of control over the work and the individual's opportunity for profit or loss, as core factors that are the most probative for determining employee status. The rule provides that if both factors point toward the same classification, there is substantial likelihood that it is the accurate classification. The rule further states, quote, this is because other factors are less probative and in some cases may not be probative at all, and thus are highly unlikely, either individually or collectively, to outweigh the combined probative value of the 2 core factors, unquote. DOL issued a final independent contractor rule in January 2021. When the final rule was issued, DOL maintained that a focus on the 2 core factors would, quote, improve the certainty and predictability of the economic reality test, unquote. However, many viewed the rule as inconsistent with the economic reality test. They argued, for example, that the test requires equal consideration of all of the various factors. Moreover, they feared that emphasizing the 2 core factors would narrow the scope of who may be considered an employee. In March 2021, the agency proposed withdrawing the rule. Among the reasons provided by the agency was its skepticism that the rule is, quote, fully aligned with the FLSA's text and purpose, unquote, or case law applying the economic reality test. DOL sought comments on its proposal to withdraw the rule, with the comment period ending on April 12, 2021. Notably, by identifying an individual's opportunity for profit or loss as a core factor, the new rule would seem to resemble more closely the approach taken by the NLRB for determining employee status in SuperShuttle. While it may be possible to distinguish entrepreneurial opportunity as a core factor from the prism of entrepreneurial opportunity through which to view other common law factors, DOL and the board both appear to elevate entrepreneurial opportunity as a consideration for distinguishing between employees and independent contractors. End of Section 5. Section 6 of Worker Classification, Employee Status under the National Labor Relations Act, the Fair Labor Standards Act, and the ABC Test by John A. Shimabukuro of the Congressional Research Service. This LibriVox recording is in the public domain. The ABC Test. At least 20 states and the District of Columbia have adopted a multi-part test to determine whether an individual should be classified as an employee or independent contractor for purposes of their unemployment compensation programs and or at least some of their employment laws. The so-called ABC test presumes that an individual is an employee and not an independent contractor unless the hiring entity can establish the following three elements. A, the individual is free from the entity's control or direction in performing his work, both under a contract for the performance of such work and in fact. B, the work performed by the individual is outside the usual course of the entity's business. And C, the individual is customarily engaged in an independently established trade, occupation, or business of the same nature as the work performed for the entity. This test has been deemed the ABC test because all three elements must be satisfied before an individual will be classified as an independent contractor. The 20 states, as well as the District of Columbia, that have adopted the ABC test through legislation or judicial decision are identified in the appendix. The appendix may be viewed in the printed version of this work. The appendix is organized by state and three areas where the ABC test has been prescribed: for purposes of a state's unemployment compensation program, for purposes of a state's wage and hour or other employment laws, and for purposes of a specific industry's employment standards, for example, the construction industry. The appendix includes excerpts from the relevant statutes, as well as case descriptions when the use of the ABC test has been judicially prescribed. By presuming a worker's status as an employee and placing the burden on the hiring entity to establish that the individual is an independent contractor, proponents of the ABC test believe that employers may be less likely to misclassify their workers. They also contend that the ABC test provides greater predictability about employee status because courts and administrative bodies do not have to weigh a variety of factors, as required by the economic reality and common law agency tests. Critics of the test argue, however, that greater use of the ABC test will likely discourage businesses from contracting for services or retaining freelance workers. These businesses may be reluctant to accept an employer-employee relationship that does not currently exist and would require compliance with the various laws that protect employees. The predictability arguably provided by the ABC test was discussed by the New Jersey Supreme Court when it prescribed the test's use for purposes of two of the state's employment laws. In Hargrove versus Sleepy's LLC, the court sought to identify the appropriate test for employee status determinations for the Wage and Hour Law, or WHL, which prescribes a minimum wage and the availability of overtime pay for hours worked in excess of a 40-hour work week, and the Wage Payment Law, or WPL, which governs the timing and method of wage payments. Regulations issued by the New Jersey Department of Labor to implement the WHL incorporated the ABC test used in the state's unemployment program. However, neither the WPL nor its implementing regulations similarly prescribed the use of the ABC test for employee status determination. After considering the plain language and similar purposes of the WHL and WPL, the court concluded that the ABC test should be used to determine an individual's employee status for purposes of both laws. The court maintained that there was no good reason for disavowing the WHL regulations or disregarding the long-standing practice of implementing both statutes in a similar fashion, noting that, quote, statutes addressing similar concerns should resolve similar issues, such as the employment status of those seeking the protection of one or both statutes by the same standard, unquote. In prescribing the use of the ABC test, the court also observed that the test provides more predictability for workers, in contrast with the economic reality test. Unlike the latter test, which could, quote, yield a different result from case to case, unquote, the court determined that the ABC test would likely identify fewer individuals as independent contractors because each of the three elements had to be satisfied. Accordingly, the court maintained that, quote, the ABC test fosters the provision of greater income security for workers, which is the express purpose of both the WPL and WHL, unquote. The court's interest in adopting a test that yields more predictable results also prompted it to reject an alternative common law test that encompassed the economic reality test but focused on a totality of the circumstances evaluation of the hiring entity's control over the individual. In criticizing this alternative test, the court observed that, quote, permitting an employee to know when, how, and how much he will be paid requires a test designed to yield a more predictable result than a totality of the circumstances analysis that is, by its nature, case-specific, unquote. In Dynamex Operations West, Incorporated versus Superior Court of Los Angeles County, the California Supreme Court also acknowledged the greater clarity and consistency provided by the ABC test. In Dynamex, a 2018 case involving delivery drivers for a package and document delivery company, the court considered the appropriate employee classification standard for purposes of California's wage orders. These orders impose various wage and hour requirements, including certain mandatory meal and rest periods, for different industries operating in the state. After reviewing the provisions of the applicable transportation order and considering its objectives and past judicial interpretations of the state's wage orders, the court concluded that the ABC test should be used to make employee status determinations. The court explained that the ABC test is faithful to, quote, the fundamental purpose of the wage orders and will provide greater clarity and consistency and less opportunity for manipulation than a test or standard that invariably requires the consideration and weighing of a significant number of disparate factors on a case-by-case basis, unquote. End of Section 6. Section 7 of Worker Classification, Employee Status under the National Labor Relations Act, the Fair Labor Standards Act, and the ABC Test by John A. Shimabukuro of the Congressional Research Service. This LibriVox recording is in the public domain. The ABC Test and Federal Legislation. Although the ABC test is not currently used to determine employee status for purposes of federal labor and employment laws, legislation that would adopt the test for the NLRA has been introduced in the 117th Congress. The Protecting the Right to Organize Act of 2021, H.R. 842, Senate 420, would amend the NLRA's definition for the term employee to add the following, quote, an individual performing any service shall be considered an employee and not an independent contractor unless A, the individual is free from control and direction in connection with the performance of the service, both under the contract for the performance of service and in fact. B, the service is performed outside the usual course of the business of the employer. And C, the individual is customarily engaged in an independently established trade, occupation, profession, or business of the same nature as that involved in the service performed. Representative Bobby Scott, the bill's House sponsor, contends that the amended definition will, quote, prevent employers from misclassifying employees as independent contractors in order to prevent their workers from organizing, unquote. The revised definition for the term employee could expand the potential pool of workers eligible for unionization, specifically by establishing a presumption of employee status for purposes of the NLRA. It seems possible that the bill's enactment could increase union membership in the United States. According to the Bureau of Labor Statistics, the union membership rate for private sector employees in 2020 was 6.3%. The House passed H.R. 842 on March 9, 2021, by a vote of 225 to 206. If H.R. 842 were enacted, it may arguably provide the predictability proponents of the ABC test espouse. By amending only the NLRA, however, the economic reality test and other standards for determining employee status would continue for other employment laws. Legislation that would have more broadly adopted the ABC test was introduced during the 116th Congress. The Worker Flexibility and Small Business Protection Act of 2020, or WFS-BPA, H.R. 8375, Senate 4738, would have adopted the ABC test for purposes of 7 labor and employment laws: the NLRA, the FLSA, the Occupational Safety and Health Act, the Federal Mine Safety and Health Act, the Migrant and Seasonal Agricultural Worker Protection Act, the Davis-Bacon Act, and the Walsh-Healy Public Contract Act. To date, the WFS-BPA has not been reintroduced in the 117th Congress. End of Section 7, and end of Worker Classification, Employee Status under the National Labor Relations Act, the Fair Labor Standards Act, and the ABC Test.